Chair Cohen, Ranking Member Johnson, and members of the subcommittee, thank you for the opportunity to testify today. My name is Sophia Lakin, and I am the Deputy Director of the ACLU's Voting Rights Project. The VRA is one of the most successful pieces of civil rights legislation in our history. But 8 years ago in Shelby County versus Holder, the Supreme Court gutted the VRA's most powerful provision, the Section 5 preclearance system. My colleagues have testified powerfully about the importance of restoring the system. After Shelby, the principal means to protect against discrimination in voting is Section 2 of the VRA, which authorizes challenges that can be brought only after a law has been passed or a policy implemented. But Section 2 itself has been under attack in recent years in at least 3 ways. First, the Supreme Court in Shelby based its ruling in part on the assumption that plaintiffs would be able to obtain preliminary relief before an election to guard against elections going forward under regimes that are later struck down as discriminatory. But the theoretical availability of such relief has proven to be inadequate. The current standard for obtaining a preliminary injunction, including a showing of a likelihood of success on the merits, is a particularly high bar to relief in voting cases, given their complexity and fact-intensive nature. These cases also take multiple years to litigate, which means many elections involving hundreds of elected officials can take place under regimes that are later found to be discriminatory, an irrevocable taint on our democracy that we have, unfortunately, seen play out many times. My prior written testimony describes 15 cases in which voting rights plaintiffs who ultimately succeeded were unable to obtain preliminary relief while their cases were pending, with numerous elections taking place, millions of voters casting ballots, and hundreds of elected officials taking office under regimes courts ultimately find are discriminatory or are abandoned. Second, this problem has only worsened due to the metastasization of the so-called Purcell principle. This is the idea that courts should be cautious changing election rules if an election is imminent. But what began as a common sense warning to consider potential voter confusion and administrative burdens now operates as almost a per se bar against intervening as an election draws near. The use of Purcell to block relief has exploded in recent years, from 6 times in 2012 to 11 in 2016 to 58 in 2020. And the doctrine is continuing to expand well beyond the common sense warning in the Supreme Court decision that is the Purcell doctrine's namesake. Purcell is invoked today, even when there is no risk of voter confusion, little to no administrative burden, and where plaintiffs have acted as quickly as they can, or there are unforeseen emergencies, like an unprecedented pandemic. And it has taken over the analysis of whether to order relief, even when there's been a strong finding that the election rule being challenged likely violates the Constitution or the VRA. Worse yet, all too frequently, Purcell is wielded inconsistently in one direction only, to undermine efforts to ensure that discriminatory practices are blocked before they can taint an election. My written testimony for today and earlier this summer highlight numerous examples. Left unchecked, Purcell threatens to kneecap voting rights litigation nationwide. Third, compounding all of these challenges, the Supreme Court's recent decision in Brnovich versus Democratic National Committee has further undermined Section 2 as the robust weapon to combat voting discrimination this body intended it to be. The decision raises the bar for voting rights plaintiffs to show an actionable burden on voters, while at the same time dramatically lowers the bar for government defendants, allowing the mere specter of voter fraud without any evidence to justify discriminatory practices. Fortunately, for all of these issues, Congress has the power to act to protect voting rights. Congress has the clear authority to set standards for the issuance of preliminary relief and injunctions in voting rights cases, and the clear ability to correct the misinterpretation of the VRA contained within Brnovich. Not only does Congress have the power to act, it also has the responsibility. Racial discrimination in voting continues to threaten the health of our democracy. Section 2 is an important and necessary tool to combat that threat, and its continuing vitality is critical. Thank you.